Latin terms are commonly used in law, and while they may sound highfalutin and so forth, I have to say that their doctrines are pretty straightforward and pretty clear. The doctrine I would like to speak about today is known as Respondeat superior, and essentially that means that the employer is responsible for the actions of its employee in the course and scope of employment of that employee. And it's interesting, when I have reviewed cases that have been prepared by younger lawyers, there seems to be an over-focus on the notion of respondeat superior. And I say that because most of the time it will not be at issue. It will not be disputed. There are times, however, of course it will be disputed, and if it is, it has to be dealt with in an appropriate fashion. But where it's conceded, where it's granted, which, as I say, is often the case, there need not be any perseveration because it's a very commonly understood doctrine. And it means that the employer will be liable, and it means that the employer's insurance policy will be responsible if everything else is proven, such as the underlying negligence, that is, the negligence of the employee. And again, it all depends on the facts. If the facts are very straightforward, that a bus driver was driving in the course and scope of his employment for a bus company, then there will be clear liability on the part of the bus company, and that connection between the employer and employee need not be focused on unduly. And again, the employer's insurance will come into play. In fact, when I am dealing with a case where there is respondeat superior, I may not even name as a defendant the employee in the hypothetical I just gave. That would be the bus driver. I just may name the bus company. So, as I said, there are exceptions to this notion. And the notion, again, of respondeat superior is another term, is the notion of vicarious liability. The employer or master should be held vicariously liable for the torts or negligence of its employee, servant, committed within the scope of employment, according to case law in Massachusetts and in really every other jurisdiction in the United States. Recently, the highest court of Massachusetts dealt with a case known as Lev versus Beverly Enterprises, and in it there was a meeting in a restaurant between the employer and employee, and then the employee left to go home, the meeting having been concluded. And that evokes one of the exceptions, and the exception is known as the comings and going rule, that when an employee is going home from work or going to work, the employment relationship in most instances is deemed not to have started or not to have continued, and thus the employer will not be responsible once that meeting in that restaurant was concluded and the employee went home. There was no vicarious liability, there was no respondeat superior implicating the employer, and you'd have to deal with that. That was an auto case on the auto insurance policy of the driver/employee, but not the employer. I find it interesting. Right now I'm dealing with a case where there is a dining service delivery, and it seems to me that that company compensates a driver for the number of deliveries they can make. So the driver has a clear incentive to go fast and not to be cautious, or as cautious as he or she might. Now, if the negligence is clear on the driver, say the driver hit a pedestrian walking in a crosswalk, why do I discuss the employer's policy of remuneration, of paying the employee? Well, if I could get that evidence in, it would indeed give good background and would indeed support the theory that the employee was riding his bicycle for the delivery too fast. It all comes down to, and I'll discuss this in another blog soon enough, it all comes down to the facts of the case. But to return to the beginning here, do not forget respondeat superior or vicarious liability when you're dealing with the negligence of an employee. Thank you.